we have known for all these decades now as affirmative action. The president just addressed the nation live from the White House. Let me give you just a minute or so of what he had to say, and then I want to juxtapose that by telling you what Kevin McCarthy, the Republican Speaker of the House, just had to say. Here now, the President of these United States.
45 years, the United States Supreme Court has recognized the college's freedom to decide how to build diverse student bodies and to meet their responsibility of opening doors of opportunity for every single American. In case after case, including recently, just as a few years ago in 2016, the court has affirmed and reaffirmed this view that colleges could use race not as a determinative factor for admission, but as one of the factors among many in deciding who to admit from a already qualified pool of applicants. Today, the court once again walked away from decades of precedent and as the dissent has made clear. The dissent states in today's decision, quote, rolls back decades of precedent and momentous progress, end of quote. I agree with that statement from the dissent. The court has effectively ended affirmative action in college admissions, and I strongly disagree with the court's decision.
That's the President of the United States strongly disagreeing with the court's decision this morning. This now from the Republican Speaker of the House, Kevin McCarthy, and I quote, "The Supreme Court has just ruled that no American should be denied educational opportunities because of race. Now, students will be able to compete based on equal standards and individual merit. This will make the college admissions process fairer and uphold equality under the law." Their two positions could not be more diametrically different. No surprise there. I welcome now into this conversation the host of You Must Learn, distinguished UCLA professor, Dr. Tyrone Howard, and the chief national political affairs analyst and host of A More Perfect Union, Sundays on the 10s. Both of these brilliant minds host programs on this station, and how pleased am I in a moment like this to have this stable of black brilliance, black excellence to tap into for a conversation such as this at a time such as this. Dr. Howard, how are you today, sir?
I'm hanging in, Tavis. How you doing this morning?
I'm doing the best I can. And as I say all the time, if I complained, I'd be an ingrate, but I got some complaints this morning. Dr. Quartey, how are you, sir?
I'm holding on to hope.
There you go. That's all we can do in moments like these is hold on to hope. Dr. Howard, you first. I don't need to even ask anything. I'll just say go.
Yeah, court got this wrong. At least the majority got it wrong. And I think this is another way in which we see how white supremacy plays itself out, that any type of advancement from black folk and other folk of color, it seems a threat to white dominance. And I think the court basically wants to say that, as Justice Thomas said, the colorblindness is what the Constitution is all about. It's never been the case. We're going to see a dramatic decrease in the number of black and brown folks on campuses. And it's just another reminder of the work we've got to do to ensure that we don't let the roots of racism deny what so many folks have fought for. And I'll also add this, Tavis. Part of what bothers me about this ruling is this idea that somehow there are all these black folks on campuses who are there, who are unworthy, who are undeserving, who are not highly talented and brilliant, contributors to the campus environment. I'm on these college campuses. I do not see these numbers that I think folks are fearful of. But there's this prevailing belief that if there's one black student that's there, and that he or she is a little bit more unqualified than a white student, that there's something wrong with that, and that has to be undone. And finally, I'll say this. Folks are upset about the kind of privilege they think that comes from having race being a factor, not being the factor. But we got legacy admissions that have been happening for decades upon decades in this country. So we're okay if your father or grandfather writes a $10 million check and you get in and you're an average student, but you want to sort of raise, all kind of fuss about the fact that if a black student gets in who you perceive to be not qualified, then that's a problem.
Dr. Quartey, go.
Also, as not just a journalist, but also as a professor at Pepperdine University, I was thinking right away of the diversity that I've enjoyed in my own classroom. Black students and Latino students and LGBTQ students, right? And the opportunity that being in graduate school, may afford them. And, I'm saddened today, about how my classroom may look my classrooms like mine in public colleges and universities may look vastly different come next fall. And to Dr. Tyrone's point, former First Lady Michelle Obama, sort of lifted up this sentiment so eloquently, saying, quote, "So often we just accept that money, power, and privilege are perfectly justifiable forms of affirmative action, while kids growing up like I did are expected to compete when the ground is anything but level." So today, the former First Lady continues, and she says, "My heart breaks for any young person out there who's wondering what their future holds and what kind of chances will be open to them." This opens a can of worms, Tavis, on a number of fronts. And it's not just going to stop at college admission, as you mentioned. There is an outright war on diversity, equity, and inclusion. And so, if we think that companies have been a little bit reticent in terms of showing their support for various communities in recent months, fasten your seatbelt and get ready. I think that's part of the reason why in the president's address to the nation just moments ago, he called on corporate America to, hold true to their commitments around diversity, equity, and inclusion. This is the same president, I might remind you, that one of his very first executive orders was the Racial Equity and Support for Underserved Communities executive order, where, he's been committed to a whole of government approach to advancing racial equity. And so this is the president that got up there today, not just reacting to the Supreme Court's decision, but reacting to how that decision may counter some of the heavy lifting that his administration has been doing since day one.
We will talk about what now. We will talk about what next when we come forward with our own team, the home team. The host of You Must Learn, Saturdays at 10 a.m. here on KBLA Talk 1580, Dr. Tyrone Howard, and the host of A More Perfect Union, Sundays on the 10s, Dr. Nii-Quartelai Quartey. We're all right now together with you on KBLA Talk 1580.
To talk about. Good thing we've got 3 hours. More of Tavis Smiley when we come forward.
The pandemic may be over, but many Angelinos could be at risk of losing the place they call home. It's important to know your rights as a residential renter in the city of LA. Did you know eviction protection still exists for unpaid COVID-19 rental debt that was due before March 31st, 2023? And that you have 5 days to respond to an eviction notice, also known as an unlawful detainer. Learn more about your rental rights at housing.lacity.org. Be informed, be protected, be at home.
You're listening to K-Drip, where we play all the best classic water-wasting hits like Sprinklers in the Rain and Leaky Faucets. They're tunes from another time because now that we face a hotter, drier future, every drop counts. Despite an extremely wet winter, keep using less water, fixing leaks, and reusing indoor water for your garden. Visit SaveOurWater.com for more ways to conserve. Up next, brushing your teeth with the water on. K-Drip.
Mom's early Alzheimer's diagnosis was hard to take.
And when I left the oven on, we decided together that it was time to see a doctor and make a plan.
Early detection gave us more time to seek out information and support as a family.
If you or your family are noticing changes, it could be Alzheimer's. Talk about seeing a doctor together. For more information, visit alz.org/time to talk. A message from the Alzheimer's Association and the Ad Council.
At Lowe's, we're always bringing pros more ways to save. Right now, save on Valspar 5-gallon Ultra Flat Paint. Was $131, now just $123. Plus, MVP's Pro Rewards members earn up to 900 bonus points with the purchase of a Graco Magnum X7 paint sprayer. Lowe's knows pros. Valspar offer valid through 8/2. Selection varies by location. Estimated bonus points valid through 6/30. Actual awarded bonus points calculated on purchase price before taxes and after applicable discounts, if any. Subject to program terms and conditions.
Interrogating your assumptions and expanding your inventory of ideas. Let's get back to Tavis Smiley on KBLA Talk 1580.
No, we need it so bad.
Dr. Tyrone Howard, how do we use the soul power that we have in this present moment, sir?
Yeah, I think it's appropriate, Tavis, that you are reminding us of James Brown, and he was critical to our fight for justice and recognition and inclusion. And that's what we've got to do in this moment. We've got to channel our collective efforts and energy to make sure that this decision does not deter us. And by that, what I mean is now universities have got to be creative. They've got to be innovative. They've got to begin to say, listen, we're not going to throw our hands up just because of this ruling. We're going to be much more thoughtful in our recruiting. We're going to encourage black and brown folks about how to become competitively eligible at these colleges and universities. We're going to change our outreach efforts. We're going to reach out to high schools and churches and mosques and all the places that we know that black and brown folks are. This is now on universities to be creative. What I hope does not happen in this moment is that universities throw their hands up and say, well, you know, we want to be diverse. That's part of our mission, but we can't be because the court has made this ruling. I think UCLA is an example of what can happen. By no stretch of the imagination is UCLA the beacon of diversity when it comes to black folks in particular, but we know Proposition 209 has been in place for close to 30 years in the state of California. And so what UCLA had to begin to do with the tremendous and fierce leadership of one Yolanda Copeland Morgan, she began to mobilize alumni associations. She began to do insistent outreach. She began to talk to folks about the fact that, listen, even though race cannot be a factor, you can still write about your experiences as a black person or a brown person in your essays to the admissions committee. So that way you still can lift up what it means to be black or brown in a predominantly white society. So I think we've got to be innovative, in some cases subversive, but we cannot be deterred by these rulings.
Dr. Quartey, you hear Dr. Howard suggest that he hopes that universities will not look the other way, that is. My experience has been that institutions oftentimes do only that which they are demanded, ordered to do, in part because it takes vision, it takes creativity, and it takes a greater effort to do it. Now, if you believe in it, you advance those issues. But oftentimes, again, people only do what they are mandated to do. And if they're not mandated to do it, then they don't do it. So I hear his hope that institutions won't look the other way. But how do you read this moment?
You know, I very much like Dr. Tyrone, you know, I think that this has the potential to unleash a level of innovation in higher education that we have not seen in a long time.
Mm-hmm.
And I'm thinking of my alma mater, the University of Southern California, where our brother, Dr. Sean Harper, who's the executive director of the USC Race and Equity Center, this Friday from 12 to 1 p.m. Pacific is hosting a national forum on legally allowable ways to sustain racial equity initiatives on college campuses in the post-affirmative action era. And so USC's Race and Equity Center not wasting any time organizing folks of conscience, folks that believe in affirmative reaction, organizing them in this forum to educate folks on the legally allowable ways we can sustain racial equity. And so in addition to really leaning into those personal essays and telling our story in ways that make clear the fullness of who we are and the hurdles that we have, that we still must overcome. That's all going to be critically important in the days ahead. And, you know, we cannot let folks backtrack from commitments to racial diversity, especially in a time such as this.
So yesterday, Nii-Quartelai, you'll appreciate this given that you're in Washington. I did a interview yesterday at the Washington Post about affirmative action. We all knew this was imminent, and so I sat for about 30, 40 minutes with the Washington Post yesterday for a piece about affirmative action again. And there were a number of things that came out of that conversation. One of the points I made, though, in that dialogue was that our white brothers and sisters may be relatively quiet today, but as I've said, as you've said, as Tyrone has amened, this is not the end, it's the beginning. It's affirmative action in college admissions, but they will go after employment. They will go after contracting. They're not going to stop. Our white brothers and sisters may be relatively quiet today, but when they get to employment and when they get to contracting, somebody's going to say something, and I mean somebody white, because the data is incontrovertible in this regard. White women have benefited as much as anybody from this corrective program named and called affirmative action, because those white women are married to white men who put those white women down on paper as the president of their companies. Let's just keep it real. They get listed as the president of the companies and win all of these contracts, MBE, WBE. We just talked to Stephanie Wiggins, the CEO of Metro, about MBE, WBE contracts. But a whole lot of white folk, white women, white husbands, and their white families, their white households have benefited greatly from affirmative action. So they may not say anything today because this betters the chances that more of their white kids will get seats in these classrooms. But when it comes to employment and when it comes to contracting, excuse me, somebody's going to say something. I don't know whether it'll be too late at that point. And I'm just offering that as a way to see a little further down the road, Nii-Quartelai, but I yield to you for your thoughts.
Yeah, I mean, this is, as you walk through the potential long-range impact this may have, right away I started thinking about, what does this mean for legacy-based admission? So if you can't check a box on an application to indicate, your race, well, can you indicate that you're legacy? And if so, doesn't that give legacy kids a leg up? And so I'm still pouring through the decision, but these are some of the questions that sort of came up to me. What are some of the implications in terms of scholarships? There are plenty of race-based scholarships out there, right? And so, does this affect how colleges and universities can dole those out? And there's undoubtedly, there will be an economic impact for Black folks and other folks of color, when it comes to going to college, right? And so if our access has been limited, right, and if access to scholarships and financial aid may be limited, at least from a race-based perspective, then where do we go? And one place we might go, where we have gone for a long time, my parents went to an HBCU. In fact, they met an HBCU in Texas. This may be a boon to historically Black colleges across the country, and to PWIs, predominantly white institutions. They may be wise to strengthen their consortium agreements, with HBCUs, in order to maintain a level of diversity in the classroom and on campuses.
What about that latter point that Dr. Quartey makes, Dr. Howard, about the impact this might have on HBCUs?
Yeah, I think this is an opportunity. I think Dr. Quartey is spot on. I think this is where HBCUs have to do a really robust outreach to say, listen, we want you here. We value you here. You will thrive here. We still know that the majority of physicians and dentists and attorneys and educators are products of historically Black colleges and universities. So I would hope that parents and young people who are going to be applying to colleges would consider historically Black colleges and universities. But at the same time, I'm not going to let these predominantly white institutions off the hook.
Yes.
You say that you value diversity. You say that you want diversity. You put pictures of Black folks on your flyers and on your website. If you really value that, then what's your commitment to double down with your resources and your efforts to make sure that you understand that this has been a setback, but a setback, as my grandmother always said, is a setup for a comeback. How do we come back from this situation now? And I think there will be some universities who are going to take the lead on this, predominantly white institutions, that is, and be out in front to do this. But I think you make an excellent point, though, here, Tavis. I think we have to remember that affirmative action in its original intent was not solely based upon racial preferences, but also gender preferences. Mm-hmm. So in this moment, where are white women who are standing up and speaking out to say, listen, we have been major benefactors of this. We are also going to stand up when it comes to racial preferences. But again, I think the silence is deafening. I think it speaks volumes. And I think part of what we don't do is the very point that you lifted up is understand when you do a deeper dive on the data, it shows over and over again that white women have benefited from affirmative action more so than folks of color have been. And to me, that's deeply troubling. And the final thing I'll say on this, Tavis, is that, look, I'm always intrigued with what happens on college campuses because we have no problem being in a position to see Black folks run up and down a football field or run up and down a basketball court when it increases the bottom line for institutions. Mm-hmm. So we're all for affirmative action in the athletic domain, but there's something about seeing a Black person in the engineering lab or in the journalism classroom or in the economics classroom that just really just undermines the very sort of essence of what some folks think education should be about. So I think at the end of the day, when I think about this moment, I'm reminded of the work of the prolific writer Carol Anderson when she talks about white rage. And she said the thing that really intensifies white rage is Black advancement. Any sign that Black folk are making advances or making progress or struggles oftentimes just serve as the catalyst for white rage because they operate oftentimes from a zero-sum game. If you are getting something, you must be getting something at the expense of me getting something, and that's what we have to continue to fight.
Tyrone Howard is teaching and preaching here on KBLA Talk 1580. Watching my clock, about 90 seconds. Last word to you, Nii-Quartelai. Let me come straight to the politics of this, which I know you'll be unpacking in great detail this Sunday on A More Perfect Union, heard Sundays on the 10s on this program. But my final question, the exit question is, what do you make of the politics? Again, no surprise here, but here again, another 6-3 vote, Nii-Quartelai.
Yeah, I mean, this is certainly we can expect former President Trump, who still is a contender for the GOP nomination for president. We can expect, him to take some credit for this because, the justices that he appointed to the Supreme Court pushed this thing over the top, right? Mm-hmm. And so, in addition to sort of owning the demise of Roe v. Wade, that precedent, that precious precedent over women's reproductive rights, is another precedent here on affirmative action that is gone and was helped by the appointments of former President Donald Trump. And so you can expect for this to be an issue during the campaign cycle, if not for that, for the fact that by this time next summer, we have the next class of students that will be preparing to head to colleges and universities in the fall, and they may look very different from the students that may be going into public colleges and universities this fall.
We celebrate and try to embody Black excellence here at KBLA Talk 1580, and I could not be more delighted to call both of these brothers, these gentlemen, colleagues here at this station. Dr. Tyrone Howard is president of the American, let me get it right, Dr. Howard, give it to me again. American
Educational Research Association.
That's it. That's right. National president of that organization. Yeah, that part. Also a distinguished professor at UCLA and host of You Must Learn, heard Saturdays at 10 a.m. exclusively here on KBLA Talk 1580, and our friend and brother and chief national political affairs analyst and host of A More Perfect Union, heard Sundays on the 10s here on KBLA Talk 1580. Dr. Nii-Quartelai Quartey has joined us as well in this hour. When we come forward, Judge LaDoris Cordell and her take on this. But for now, Dr. Howard, thank you for your time, sir. I appreciate you. All the best to you.
Be well, Tavis.
You too, man. We'll hear your program Saturday morning at 10 a.m. And can't wait to Sunday for all 2 hours, both hours of A More Perfect Union to see how Nii-Quartelai unpacks this on Sunday. Dr. Quartey, appreciate you, sir. We'll talk to you soon.
Always a pleasure.
Judge LaDoris Cordell with her take on the gutting of affirmative action in college admissions when we come forward on KBLA Talk 1580.
A safe place to go loud. A great place for progressive politics. KBLA Talk 1580.
I'm Mike Moore. Here's the latest from the Black Information Network. In Virginia, lawyers for the Otieno family don't think the prosecutor is qualified to handle the case. Civil rights attorney Ben Crump announced yesterday that he and his co-counsel have petitioned the U.S. Justice Department to prosecute the 8 suspects in Ivo Otieno's death. The 28-year-old black man died 3 months ago while in police custody in Dinwiddie County. His death was ruled a homicide. Millions of Americans may be impacted by unhealthy air quality due to smoke from Canadian wildfires. As of earlier today, 23 states are under air quality alerts from the Midwest to the Northeast and parts of the South. The smoke is expected to cover the areas in the Great Lakes, Appalachian Mountains, and Ohio Valley as the day moves on. And that's the latest. I'm Mike Moore from your 24/7 news source, the Black Information Network and BINnews.com.
Did cancel that Sigler in Studio City that crashed from overnight, cleared from all traffic lanes on that 101 eastbound at the 134-170. Still a tough drive from Encino. It's right around White Oak where you're on and off the brakes. A wreck in North Hills, slowing our drive on that 405 south. Approaching Roscoe, the right lane is what's blocked. As you get to the 118, we have a tough commute. South LA, the 105 west of Vermont, a crash from earlier on the right shoulder. That has us slow from around the 710 freeway. And the 5 south at Roxford had a wreck in Granada Hills, Sylmar. That is cleared, but we're busy here from at least the 14.
When your ride fires on all cylinders, so do you. That's why Napa is on a mission to keep you in motion. With nearly 6,000 Napa Auto Parts stores and over 17,000 Napa Auto Care centers, the Napa Network has everything you need to get up and go.
This is the KBLA Sports Minute with Ray Richardson.
The Lakers got a jump on the NBA's free agency period, which begins Friday at 3 p.m. They made qualifying contract offers to restricted free agents Austin Reeves and Rui Hachimura. Reeves and Hachimura are expected to attract some interest in the free agent market. By putting qualifying offers on the table, the Lakers can match any contract offer Reeves and Hachimura would get from other teams. The Lakers really want to hold on to these two, especially Reeves. The Lakers already know several teams are interested in Reeves. The best deal the Lakers can offer him is $50 million over 4 years. Reeves can get more money from other teams, but the Lakers made him a rising star in the league. We'll find out soon how much that means to Reeves. New York Yankees pitcher Domingo Germain threw a perfect game last night against Oakland. 27 batters up, 27 down. No debates, no speculation, just the info you need. That's your KBLA Sports Minute. I'm Ray Richardson. More news, opinions, and conversation when we come forward on KBLA Talk 1580.
Are you a small or micro business owner looking for ways to succeed after the pandemic? LA County has got you covered. Gain access to economic opportunity grants and technical assistance to help your business thrive. Whether you need mentorship or capital investment programs, they're here to help. Find out if you qualify at recovery.lacounty.gov/programs. That's recovery.lacounty.gov/programs. LA County and you, moving forward together.
Buying your dream home can be exciting, but it might take some sacrifice. But don't worry, Rocket is here to give you a hand. If you buy with Rocket Homes and finance with Rocket Mortgage, you could get up to $10,000 cash toward closing from Rocket Mortgage. That's a big deal. Why not see how Rocket can help you start your legacy? You got this, and Rocket's got you. Only with Rocket. Visit onlywithrocket.com to get started.
For purchase transactions only must like rate between 331 and 831. Call 8337-ROCKET for conditions and restrictions. Allows a rental license in all 50 states. NMLS Consumer Access. Number 33.
Where are we on the lineup?
It's official. Avery is producing Main Street Music Days.
We need to be ready. We're going to have lots of people. What's the status on the new sound engineer?
They need an audio technician to keep things level from sound checks to encores.
Make sure audio from one stage does not compete with another.
Indeed can help them hire great people fast.
I need Indeed.
Indeed you do. Our hiring platform instantly connects you with quality candidates, and you can schedule and conduct virtual interviews right from the Indeed dashboard. Visit Indeed.com/credit and get $75 towards your first sponsored job. Terms and conditions apply.
At KBLA Talk 1580, we do more than just talk.
You got a big mouth. Hello, Joe, you're up. Welcome.
We're unapologetically progressive, and we don't black down.
About the good thing. About the bad thing. About the right thing. About the wrong thing. The later before you leave me, belong, 'cause I'm the one who love you. Think about the sacrifices that I made for you. Think about the hard times.
45 years, the United States Supreme Court has recognized the college's freedom to decide how to build diverse student bodies and to meet their responsibility of opening doors of opportunity for every single American. In case after case, including recently, just as a few years ago in 2016, the court has affirmed and reaffirmed this view that colleges could use race not as a determinant factor for admission, but as one of the factors among many in deciding who to admit from a already qualified pool of applicants. Today, the court once again walked away from decades of precedent and as the dissent has made clear. The dissent states in today's decision, quote, rolls back decades of precedent and momentous progress, end of quote. I agree with that statement from the dissent. The court has effectively ended affirmative action in college admissions, and I strongly disagree with the court's decision.
That was the President of the United States, Joe Biden, moments ago. In case you didn't hear that at the top of the hour, I wanted to give you a sense of what the President has had to say about this gutting of affirmative action in college admissions. And here again, the comment of Kevin McCarthy, the Republican Speaker of the House, could not be more different than what the President had to say. And I quote from the Speaker, "The Supreme Court just ruled that no American should be denied educational opportunities because of race. Now, students will be able to compete based on equal standards and individual merit. This will make the college admissions process fairer and uphold equality under the law. Once again, you couldn't have two more diametrically opposed statements from the president and from the Speaker of the House. I don't need to say much more than that. I am pleased to welcome Judge LaDoris Cordell back to this program. Judge Cordell, take it away.
Hi, Tavis. This decision upends decisions from the Supreme Court that have supported affirmative action. And by affirmative action, I mean a holistic approach to admissions, meaning that race is a factor, but not the only factor in deciding who gets into these colleges. Also understand, these two colleges that were the defending affirmative action were specifically picked by this organization that sued, that was put together by Edward Blum. One is a prestigious public institution, the other prestigious private one. And this affirmative action case is really geared at the elite universities that produce and create the pipeline, especially for people of color, for people who go into law schools, become our lawyers, our judges, our engineers, and our physicians. However, that being said, this decision, in my view, did not end affirmative action in admissions. Let me say that again. Mm-hmm. This decision did not end affirmative action in admissions. And why do I say that? This decision made it more difficult and more tricky to use race, but the court did not exclude race as a factor. So there are 237 pages that comprise not just the opinion, but also the concurrences. That's the justices of the six who supported this. And there are dissenting opinions, one by Justice Sotomayor and one by Ketanji Brown Jackson. And the best way to understand a Supreme Court decision, in my view, is to read the dissent. If you read the dissent, you'll understand exactly what the majority did. So I'm going to just give you a couple of lines from Sotomayor's dissent, and you'll see why I believe and stand by the statement that this decision did not end affirmative action. Mm-hmm. Here it is. This is from it. In a single paragraph at the end of its lengthy opinion, the court suggests that, quote, nothing in today's opinion prohibits universities from considering a student's essay that explains, quote, how race affected that student's life. So that's directly from the dissent, quoting from the opinion. So while you can't say race is one of our factors, you can consider race. And I encourage applicants to any of these universities to make sure that they talk about their race when they write their essays. And what's also interesting, the court gave an exemption or an exception to military schools, colleges, and universities, saying that race can be a factor because race and diversity is important for national security. So they are hypocritical. On the one hand, they say we have to have a colorblind society. And on the other hand, they're saying, well, you can talk about race in your application, and race can be an explicit factor when we're talking about admissions to military schools. It makes no sense. Hey, one other thing.
Sure, please.
Yes, one quick thing. Mm-hmm. In Sotomayor's dissent, she just ripped apart Clarence Thomas's concurring opinion. She took every point he made, and showed that it was not supported by any kind of evidence of all, and she just ripped it to shreds. So I believe little will change in affirmative action. It's just that the universities, admissions, and colleges cannot use the words race, and they can, however, absolutely consider race as a factor as long as they don't explicitly say it.
We just had two guests. First of all, thank you for that brilliance. I was just saying moments ago that I love being able to tap into my own team here. Dr. Quartey, Nii-Quartelai, and Dr. Howard, Tyrone, just had them on for half an hour. And here we come with more brilliance, of course, judicial brilliance in Judge LaDoris Cordell. I just feel like I'm so fortunate to have all these black minds to tap into in this hour. That said, does any part of what you just said suggest to you that we aren't going to see a significant drop in the admissions of black folk and other students of color, because that is not how Dr. Howard and Dr. Quartey felt about it in the first half hour of this hour?
Sure. So there is a basis for them saying this, in that in California with Prop 209, the voters, majority of voters, those who voted, said that you can't use race as a factor in affirmative action. And so, for example, at the UC campuses, the enrollment of Black and brown students has dropped, meaning if you just focus on the socioeconomic concerns and nothing else, you're going to get a drop. What I'm saying here is that if you read this opinion carefully, and I encourage people, you don't have to read 237 pages. Just read Justice Sotomayor's and Justice Brown Jackson's dissents. You'll understand what this opinion means. So initially, I think that if people just take the approach, well, affirmative action's over, they're wrong. It's quite clear that court has said you can write about race, and it can be a factor, but you just can't say it, which is ridiculous. Understand, ridiculous. But so if we really adhere, if these admissions offices really adhere to this decision, there shouldn't be a significant drop. And also understand, the Supreme Court doesn't have the last word. Every time they've made a major decision, there's always litigation that follows. There's always litigation, and there's going to be litigation. There's going to be perhaps Asian American students, one more, or maybe it's going to be white students. And another question: what does this decision have impact on historically Black colleges and universities? I mean, in the name is Black, is race. So are they saying that they can't look at race when we're considering people? So that's not even addressed. So good luck with that. There's going to be plenty to talk about here on.
It's not funny, but it is because nobody quite put it the way Judge Cordell just put it. Yeah, if you're at Black colleges and Black is in your name, are you not to consider race when you're admitting students to Howard or Texas Southern or FAMU or whatever the case may be? I take your point. Let me come back to this, and I'm going to ask the question that I'm almost afraid to ask because you've always said how silly, how ridiculous, how stupid it is, but I'm just trying to understand what their thinking is, and I'm not naive in asking it. Why this exemption, to your mind, from a 63 decision for military schools? Why did those 6 persons carve out this exemption for military schools?
Say they know, these 6, they know how important diversity is. And they're very concerned that, wow, we have to make sure we have enough. And this is, again, just me saying this. We have to have enough brown and Black bodies to put out there to die for our country. And so why would we want to stop that? So let's make sure that we can get those bodies in there and they can go sacrifice for this country. But when it comes to these other institutions, oh, no. We're going to keep that as selective as possible. To me, that is outrageous, and it's racist. So you have it right in their words. And as I said, read Sotomayor's dissent. She talks about it and says, this is so hypocritical, this military school for national security. We're important for national security, but not important enough to go to these educational institutions? Give me a break.
Love me some LaDoris Cordell. That analysis right there, I didn't know where she was going with that, but I knew she had something for me. I wanted to know why the carve out for military schools. Now you get it. They need Black and brown bodies to put on the front lines to defend this country, but we are not good enough to go to the best institutions in this country. Again, so honored to have Judge LaDoris Cordell on this program. We'll continue with her when we come forward on KBLA Talk 1580.
Be sure to like and follow Tavis Smiley at The Real Tavis Smiley and get Twitter updates at Tavis Smiley. The conversation continues when we come forward.
I'm James Alexander, a proud member of AARP. 1967, I was 17. That spring, my friends, the Barcades, and I made Soulfinger. It was a hit. Number 3 on the charts. That summer, we became the Great Otis Redding's Band. First gig, the famed Apollo. That fall, we toured. That winter found me in a morgue identifying the bodies of my bandmates and Otis Redding. My music and their memories bring me joy. The Barcades forever.
What would you call a joy that is as solemn as it is sweet and knows no bounds? A joy that's beautifully rooted in soul and resilience. This is Black joy, a joy that reflects pride and honor despite every challenge. AARP believes the power of Black joy is limitless, and we celebrate this joy supreme. Join us in celebrating Black joy at aarp.org/Black community.
The Shadow Sister Tour is coming to Malik Books, Westfield, Culver City Mall, Friday, June 30th, 2023 at 7 p.m. Author Lily Mead will be signing and discussing her new book, The Shadow Sister. This book is perfect for fans of emotional suspense, sisters with stories with complex family dynamics, and speculative fiction, including hoodoo. Lily Mead's captivating book is a must-read, truly a page-turner. From the first line to the final page. The moderator is New York Times best-selling author of the book, The Black Kids. Come out to Malik Books, Westfield, Culver City Mall for the Shadow Sister Tour, Friday, June 30th at 7 p.m. There will be diverse books featuring strong female leads. Malik Books is a community bookstore that amplifies the voices of our community and gives voice to the voiceless. For more information, go to malikbooks.com. Again, that's malikbooks.com.
To my hometown, my community. Some of you have known me my whole life. Do you notice anything different about the kids in the neighborhood? Ever paid attention? You might start with gifts, money, attention. These are signs. Child trafficking is happening right here in this town. So don't just watch through the window. Pay attention. Because the more we know, the more we'll all know to say no. Learn the signs to look for and how to help at no-to-say-no.com.
We knew you'd stick around. This is LA's home for progressive talk radio. Be heard. Welcome back to KBLA Talk 1580.
George Cordell, you have encouraged us a couple of times now to make sure that we read the dissents in this case today. We know what the six had to say. You're encouraging us to read the dissents to really understand what this is all about, from KBJ and from Sonia Sotomayor. What impact long-term, what impact historically do these dissents actually have? Because when you were last on, we talked about all the dissents that one Thurgood Marshall put on the books, over 1,000 dissents from him just on the issue of the death penalty, as I recall from that conversation. What's the import of these dissents today from KBJ and Sotomayor?
The impact of the dissent is going to be really, really important. Understand they are the minority now. They're not the majority, but they lay out why the decision is not one that is a solid one and one that does not follow legal precedent. So I believe time will show that these dissents will eventually prevail and become the majority opinion again. This court is the sixth. When I talk about the Supreme Court, right now I'm talking about the supermajority six. They have gone rogue. They have gone rogue on a woman's right to choose, and they've now gone rogue on the issue regarding admissions using affirmative action. And the history will demonstrate that when the court has done stuff like this and really gone against popular opinion, things will change. It takes a bit of time. And in doing so, just one thing I have to mention about Clarence Thomas. Mm-hmm. One of the arguments he made was that the use of race in this, holistic admissions, which is what we do now, holistic, leading a bunch of factors. This is what he said. He said it leads to the inevitable underperformance by Black and Latino students at elite universities, and I'm quoting from him, because they are less academically prepared than the white and Asian students with whom they must compete. And it was, Sotomayor was great. She wrote, Justice Thomas speaks only for himself. And she was basically saying, yeah, you probably couldn't compete. You probably felt that you were out of your league, but that is not true statistically. And she writes about that in her dissent as well. So he's just putting out his ideas based upon his warped attitude about race and about his own people. And he's written about it in the dissent. That's why it's so refreshing to read this dissent and understand better, not just the fact that they're in the minority, but she points out, here's what the opinion actually said. So I go back to her comment about that last paragraph in their final paragraph saying, we're not going to prohibit race from being considered. The student wants to write about his or her race, put it in the essays, and it can be considered. But basically, they're saying, just don't say it out loud, which is preposterous.
That's also that line that you read from Clarence Thomas's opinion. That's also a pretty stunning and damning indictment of himself. Well, when one considers that he got into Yale Law School on an affirmative action program, is he suggesting that he underperformed at Yale? And if he did underperform at Yale, he still got a seat on the Supreme Court. He's the longest-serving justice now. That's an indictment of himself, is it not?
That's exactly right. And we all know that his seat on the Supreme Court was one that was a reactionary appointment by the first Bush after Thurgood Marshall left. And he clearly was not the most qualified person of color to sit on that bench. That man had only been a judge for 18 months, and he had worked at the EEOC for his entire legal career. He was mediocre. That's fine, but we had much better. And so here he is now writing, and again, even his reasoning shows mediocrity, in my view, and that's why Sotomayor ripped into him the way she did. And I want to add something. When Scalia, who died, was on the court, and he commented again, echoing really what Thomas has said today, but this is what he said, and this really gets me because it's so blatantly racist. This is a quote from Scalia. There are those who contend that it does not benefit African Americans to get them into the University of Texas. This is the lawsuit in 2016 that affirmed affirmative action. But let me go. Okay. Where they do not do well, as opposed to having them go to a less advanced school, a slower track school where they do well. And he says, one of the briefs pointed out that most of the black scientists in this country don't come from schools like the University of Texas. They come from lesser schools where they do not feel they're being pushed ahead in classes that are too fast for them. That is so blatantly racist and stereotypes black and brown people who are students are in school. And that's the mentality. So we have the sixth who's explicitly just said, we don't even want to deal with structural racism in America. We want to deal with the history, which is beautifully written about by Brown Jackson in her dissent, of racism in our educational system. They've just ignored it. The other thing, one last thing here, that the court relied on was a statement in an opinion made by Sandra Day O'Connor, where she said, 25 years from now, we shouldn't have to worry about having race as a part of affirmative action. And what these justices did today was like, okay, 25 years is up, so I guess we should really move on. That is absolutely absurd. And as I said, Sotomayor in her dissent just tears that apart.
When we come forward in our remaining moments, I want to talk about the point you make now about why people are looking at the clock, as it were, and not the data. You're focused on the clock, but not the data. Why is that? You're listening to KBLA Talk 1580.
The station you turn to when you've had it up to here with cultural incompetence. KBLA Talk 1580.
Mom's early Alzheimer's diagnosis was hard to take.
And when I left the Evan-On, we decided together that it was time to see a doctor and make a plan.
Early detection gave us more time to seek out information and support as a family.
If you or your family are noticing changes, it could be Alzheimer's. Talk about seeing a doctor together. For more information, visit alz.org/time-to-talk. A message from the Alzheimer's Association and the Ad Council.
Sometimes we lose, sometimes we win. Sometimes we try to fit it all in. Sometimes we don't know what's in store. Sometimes we find what we're looking for. Sometimes we're rolling easy and free. Sometimes 1 and 1 makes 3. So much to love along this ride. That's why Nationwide is on your side.
Nationwide Mutual Insurance Company and Affiliates, Columbus, Ohio.
In our community, mental health struggles can sometimes go unnoticed. The suicide rate among Black youth has risen faster than any other ethnic group. Only 1 in 3 African Americans who need mental health care receives it. African American women are only half as likely as their Caucasian counterparts to seek professional mental health services. Even those who guide us spiritually can sometimes face their own challenges. 45% of pastors say they've experienced depression or burnout to the extent they need to take a leave of absence from ministry. As people of faith, it's time to acknowledge it's okay not to be okay. You can pray and get help. Visit normalizehelp.org for more information and resources. Join us in raising mental health awareness in our community. Funded by the Los Angeles County Department of Mental Health and the Champion Counseling Center of Faithful Central Bible Church.
Let's unpack a little bit more with Tavis Smiley. The conversation continues right now.
George Cordell, I've got 3 minutes. Let me do two things right quick. I'm going to put both of them on the table at the same time, which I don't tend to do. Get out of your way and give you the 2.5 minutes we have left right quick. Number one, why is it that we are fixated on the clock, given what Sandra Day O'Connor said 25 years ago, versus the data in the most multicultural, multiracial, multi-ethnic America ever? That's number one. And number two, what are we to make of this trashing, this trampling consistently of legal precedent by this Supreme Court? Take it away.
With regard to time limit, it was in a 2003 decision that Sandra Day O'Connor wrote that in 25 years we should end race-conscious admissions. And for some reason, these justices have just clung on to that and said, okay, that's the standard we want to use. So at the oral argument on this particular case with Harvard and UNC, Justice Roberts said this. He says, I don't see how you can say that the program will ever end. Your position, he's saying to UNC and Harvard, is that race matters because it's necessary for diversity, which is necessary for the sort of education you want. It's not going to stop mattering at some particular point. So he's saying, that's what you all are saying. Yes, that's what they're saying. And then Amy Coney Barrett, one of the six, says, so what are you saying when you're up here in 2040? Are you still defending it? Like this is just indefinite? What is wrong with these people that they do not understand that structural racism, that racism is so embedded in this society that it's not going to end in 25. How long did it take for it to get instilled and baked in? So yes, this goes on for as long as there is structural racism, and they just don't want to look at it, including Clarence Thomas, who basically disputes the word diversity, says, I don't have a clue what that even means. He is clueless in that sense. So let me just move on. So the data is clear. Yeah. We know the wealth gap. We know all of that. They're just ignoring it because they're ignoring it, and they just don't want to go there. All right. So let me get back to the trampling of constitutional precedent. So the purpose of the Supreme Court is to review decisions from lower courts and to then say, okay, this is the rule of law. This is the law of the land. So the importance is they don't hear cases anew. They're reviewing, and they pick cases that have tremendous impact on the country. So that is how the court has always worked. In other words, you make a decision, you adhere to it until such time as change is necessary. So that's why we got Brown versus Board of Education. There was enough social science, there's enough information and popular opinion to say it is time to move on. In this instance, there was no reason for them to take up this case. That there was precedent already set from three cases, 1978, 2003, 2016, that just said holistic approach to admissions is fine, you can use race. So why did they do this? Because they could.
Because they could, yeah.
And because for years they've been thinking about it and they could. They have thrown this out the door, that is, adhering to constitutional precedent. Shame on them. And hopefully, their time will come.
I am out of time. Speaking of time, I'm out of it right about now. But if you want more of this black brilliance, I highly recommend her book. It's called Her Honor, My Life on the Bench, What Works, What's Broken, and How to Change It. You won't read a better book that's come out in the last couple of years. It's called Her Honor by LaDoris Cordell. Judge Cordell, good to have you back on. All the best. You will do it again somewhere down the road, I promise.
Thank you, Travis.
Thank you
so much.
Thank you for your time. Hour 3 of Tavis Smiley after news, traffic, and sports on KBLA Talk 1580.
KBLA 15.